सो ये जो जजमेंट है 3 पॉइंट वाला, ये जजमेंट बहुत इंपॉर्टेंट है। और ये जजमेंट पिटिशन नंबर रोस्टर रिलेटेड पिटिशन नंबर 1014/2024 रिलेटेड केस से है, ठीक है। और ये पूरा क्लियर कर दिए है कि अभी जो क्लबिंग का मामला है, क्लबिंग ऑल वैकेंसी जो क्लबिंग का मामला है वो साइड में रखा गया है अभी यूनिवर्सिटी वाइड। हेलो डियर व्यूअर्स, वेलकम बैक अगेन टू Dr. Islam's YouTube channel Literaria Miscellanea, and this video content is going to be a very informative one for your career molding phase and for your understanding, because this video is all about the yesterday's judgment. Yes, dear friend, the yesterday's final judgment or observations of Honorable Patna High Court bench, special bench, made with CJ, Chief Justice, and Justice Harish Kumar regarding its series of writ petitions and cases beginning from 6/04/2023 and ending with 1014/2024. So there were so many hearings, there are so many counter hearings, and after almost 2.5 years later, the final judgment, the final verdict comes out from the bench of Chief Justice of Patna High Court and Justice Harish Kumar, and this is the BSUSC final judgment 2024 on 18th April 2024. So the first short judgment that had been passed through is all about case number 1024/2024, and it is oral order by CJ, Chief Justice, and Justice Harish Kumar about reservation roster. So in short, 3 points are there, and you need to understand the 3 points very minutely to relate the case matters with the reservation roster and with the backlog vacancies. So the first 3 points here in the final judgment, the order copies, there is 3 points. A, the honorable Patna High Court, after observations, passed the judgment in correction to the appeals which were from the judgment of the Lord Single Judge. All right, that what the Lord Single Judge passed over its judgment or its observation, that they have given judgment for the reworking of the reservation roster as per the university rules of 1976 henceforth 2024. But the clubbing of vacancies of all universities as a unit should not be counted at all. So the earlier single judge observations are put aside because of impossibility or improbability to club all the universities vacancies as a unit, but it should be subject wise, category wise, and university wise. Therefore, in response to the challenge of the state against clubbing of vacancies, the special bench consisting with Chief Justice and Justice Harish Kumar have found or passed over this order to rework the reservation roster only without clubbing them. Okay, the clubbing of all the vacancies and counted them as a unit is against the rules, against the policy of University Act 1976 and henceforth in 2014. This is why the Lord's single bench judgment is put aside. The second point, it is confirmed by the Advocate General of the state of Bihar that the present roster clearance are only subject-wise, university-wise, which is totally different from the impugned judgment of the Lord single judge. So the Advocate General from the state giving favor to the Chief Justice opinion observations said that yes, the impugned judgment is totally put aside and the present roster situation is based on category wise, university wise, not clubbing them as a unit. All right, clear? Now number C point, the Honorable High Court has no issues. Yes, the other matters, the Honorable High Court has no issues on the merits of the grievance and direct the registry to place their work of reservation roster subject wise, university wise as per the learned single bench. So as per the learned single bench, the clubbing of the vacancies not possible. The clubbing of vacancies will not be done, but the vacancies can be categorized university wise, subject wise. So ये जो जजमेंट है 3 पॉइंट वाला, ये जजमेंट बहुत इंपॉर्टेंट है और ये जजमेंट पिटिशन नंबर रोस्टर रिलेटेड पिटिशन नंबर 1014/2024 रिलेटेड केस से है, ठीक है। और ये पूरा क्लियर कर दिए है कि अभी जो क्लबिंग का मामला है, क्लबिंग ऑल वैकेंसी जो क्लबिंग का मामला है वो साइड में रखा गया है। अभी यूनिवर्सिटी वाइज ये कैटेगरी वाइज सब कुछ होगा, लेकिन लॉन्च सिंगल बेंच का जजमेंट है वो इम्पाउंड जजमेंट है, उस जजमेंट को साइड एसेट करके जो फेवरेबल जजमेंट है, जो यूनिवर्सिटी एक्ट 1976 का फेवरेबल जो नियम है उसको ही मान्यता दिया जाएगा। अदरवाइज देयर विल बी वायलेंस ऑफ द यूनिवर्सिटी एक्ट। ऑलराइट, ओके। नाउ another judgment is there, and these judgments are related to LPA, Letters Patent Appeal, LPA number 604/2023. You can see in your screen 622/2023, 832/2023, 833/23, 884, 835, 836, 890 and 1007/2023. So all the LPA cases are combined together, and after hearings of these cases, of these particular filing, the special bench has passed over its observation and to some extent directed to the commission and to the education department and to the concerned authorities to do or to rework as per the new policy or as per the University Act or its clauses, sub-clauses, sections. Alright, so Patna High Court observed that reservation in appointments have always given rise to contentious issues of the applications of the percentage vis-a-vis the vacancies, which present case has stalled the appointments pursuant to the advertisement of the 2020 till today, that is 18th of April 2024. Okay, the above batch of appeals the above batch, LPA batches of appeals challenge, re-challenges, pro-challenges the learned single judge of which 2 or 3 or more than 2 or 3 main points are emerging out as a matter of contentions. All right, as a matter of solutions of the contentions. So what are the main points of the 43 or 42 points? What are the squeeze? इन शॉर्ट में क्या है, ये जो जजमेंट है ये क्या है, मतलब इतना बड़ा इतना सारा पेज जो है और उस पेज में कितना रेफरेंस है, 1976 का यूनिवर्सिटी एक्ट का रेफरेंस है, उसका क्लॉजेस है, सब क्लॉजेस है, सेक्शंस है, ठीक है, और कहीं कहीं दूसरे स्टेट का जो केस है वो भी रेफरेंस दिया हुआ है यहाँ पे। तो इतने सारे रेफरेंस और इतने सारे पॉइंट्स का स्क्वीज क्या है, मूल मैटर क्या है, वही हम आज आप लोगों के सामने शॉर्ट में देने का कोशिश करेंगे, ऑथेंटिक पूरा। सो द फर्स्ट वन इज द क्लबिंग ऑफ वैकेंसीज इन द वेरियस यूनिवर्सिटीज इज नॉट प्रोवाइडेड अंडर बिहार यूनिवर्सिटी एक्ट 1976. All right. Of course, the backlog vacancy issue to be observed under the said provided the University Act, under the same University Act. All right. So the clubbing of vacancies against the Act, and of course the backlog vacancies one need to see under the light of the same University Act. Okay, the first point. Second point, and the first point is is given or written in details in para number 2 of the judgment copy. You can relate this point to the para number 2. Okay, now in para number 4 the point is coming out that it explains the reservation exceeds 50% in certain subjects. So out of 52 subjects, 26 subjects appointments have been done, or you can say that out of 4,638 vacancies in total, the advertised vacancy in 2020, 461 vacancies had been appointed through 2 phases interview, into 2021 one phase and in 2022 second phase. The already appointed candidates should not be disturbed and should not be set off or should be set off against the case of backlog or reworking the on reservation vacancies. So the already appointed candidates, those who are very much in anxious, those who are appointed are very much in anxious about their future service continuation, because their service continuation is totally connected with the LPA cases, with a batch of LPA cases. But the judgment has finally cleared them out that they don't have to concern about their termination of their service, because their appointment have been done prior to the filing of the cases. So they should be set off. All right, provided that the big issues are not there, or the compromises have not been there with merits. All right, okay, this is written in para number 4. Now para number 6, given reference to various states case in respect to horizontal reservation of 2% from the freedom fighters and children, which only possible after clearing the vacancies. All right, after clearing the vacancies. Okay, so the 2% reservation policies were somewhere appear to be violated, and this is why a case had been filed, and the final judgment from the special bench is there that their 2% reservation, horizontal reservation, should be there, for the freedom fighters children. All right. Okay, this is written in para number 6. In para number 11, keeping in mind the recruitment, 3 recruitment since 1997, 2023 and 2024, the 3 previous recruitment and the backlog vacancies have to be counted at the cost of 3 selection process as on 2020 advertisement. So the last recruitment was in 2014 and 25% backlog vacancies were fulfilled, which is erroneous, which is not according to the University Act policy. All right. So these are the observations of the special bench, and these observations were in connection to the future steps of the Education Department, Higher Education Department and BSUSC. So the Higher Education Department of Bihar government and the BSUSC have to amend their certain rules and policies to continue the interview process, or to resume the further interview process. All right. So now it is about para number 13. So para number 13 is said, a matter of contentions arise when an interim order was passed by the learned single judge on 14/7/2021, putting a stay to further selection process. So in 14th July 2021, the learned single judge had put a stay on further selection process, but it is confirmed that 172 candidates were appointed, and then on 20th of December 2022 another stay was made, but further 289 candidates were appointed, which is a sheer violence of the orders. So this is also the observation of the special bench. So this is written in para number 13. In para number 15, out of 4638 vacancies, only 1, 2, 2, 3 have been granted for general open categories, which again a violence of 50% reservation limit. So out of, you can see the out of 4638 vacancies total, only 1, 2, 2, 3, 1223 vacancies have been granted as general or open categories, which is against the 50% reservation policy rules. All right. So this is why the commission argued that in 2014, 75% vacancies were of the university requisition and 25% of backlog vacancies. All right. So to clarify or to making the commissions I stand, they have given the clarification that 75% of the requisition of university and 25% of backlog vacancies. Okay, para number 17, in the light of para 30 of the impugned judgment. So in the impugned learned single bench judgment, that is called impugned judgment, in this judgment there is a para, that is 30, important para. So in the light of this para, the learned advocate general had asserted that there is no provision in the University Act 1976 to club the vacancies in any circumstances. I had already mentioned it, that clubbing the vacancies as a unit is totally against the policy of University Act 1976. Hence, this quoted statements of 30 is totally erroneous. Okay, so para number 19, 20, 21, 22, 23, 24, 25, 26, 27 are all related to clarification and all related to in respect to the clauses, sub-clauses, sections and the reference of the University Act 1976. All right, and the clarification of the impact judgment and the Code of 30 statements are fully erroneous. Here it is mentioned, para number 26 also clearly states that the CJ, Chief Justice and the Justice Harish Kumar find it difficult to uphold the judgment of learned single judge to the extent of its directions of clubbing the vacancies of all university, as it is contrary to University Act. Therefore, paragraph 30 quotations is clearly erroneous. So the main point of these observations come to the one point in all aspects, that clubbing of vacancies as a unit is totally erroneous, and hence the impact judgment quotation number 30 is totally erroneous. All right. Okay, so now this video is going to be a bit longer, but I am trying to give you the authentic one, the between the lines explanation of the verdict. All right, so keep patience and listen or watch the video till the end, because it will give you some fruitful informations regarding your preparations, regarding your upcoming understanding about the BSUSC's movement, the education department's gestures and its future planning. All right. Okay, para number 28 is all about the observations of backlog vacancies, which is also found erroneous under Reservation Act 1991. So Bihar Reservation Act 1991 is the act, and in this act, these backlog vacancies reservations are totally against the act. Okay, para number 30 is clearly mentioned here. It is annexure A, and annexure A of the learned single judge judgment, and it is clarified by the Honorable High Court that a new register can be maintained with approval of the employer. In no circumstances the vacancy roster should be made by considering the entire university as one unit. All right, it should be subject wise, category wise, and of course university wise. One must not be counted all the vacancies as a unit. There may be a single subject vacancies, there may be a 50 subject vacancies, but roster system should be maintained strictly. All right, para number 35 said that the main judgment are there. It said that interference against the learned single judge about backlog vacancies will be sustained. Yes, that means the interference of the Chief Justice and the Justice Harish Kumar interference of the learned single judge verdict is put aside or is set aside. All right, and the set aside of this verdict is given sustained. If backlog vacancies are to be determined, then at least for the past 3 consecutive years. And past 3 consecutive years, that means the Bihar government has had given advertisements in 1994, in 2003 and in 2014. All right. Okay, para 36 said the protection to the teachers already appointed in 2 phases in 2021 and 2022, as I had already mentioned here, remain sustained provided that they must fulfill the earlier reservation criteria. They must fulfill the earlier reservation criteria. All right, prior to the filing of the case. Okay, para number 38. Here the Honorable Chief Justice and Honorable Justice Harish Kumar said that very anxiously said, it is their observations with anguish, with a kind of condemnation, that due to the series of petitions made by the handful of discontent applicant, the entire recruitment process of 4,000 vacancies were totally halted, and hence they observe that these petitions, if sought out as per the Neutrality Act, then find plea for consideration to appointment based on the demand merit, and this will not vitiate the entire recruitment process. So this means that if the case filers discontent matters are proved to be pointed, are proved to be legal, then without vitiating the entire recruitment process, their plea should be heard properly. Alright? Okay, 39. But that does not mean the entire process should be halted. The process should be ongoing. This is a very important clarification or important directions given to the Education Department and the commissions. Alright? Para number 39. Therefore, on this purview of the above petitions, two general issues come to the fore. So the observations now come to the conclusion, and from the conclusion, two general observations or directions come to the fore, comes to our front. That is, no question of combining the vacancies in all universities for preparation of reservation roster, and hence direction of LSG states set aside. The learned single judge directions stands set aside. One. Second, while reworking on the reservation is upheld, finding the determination of backlog vacancies as per the impound learned single judge to be flawed. It is to be flawed, it is erroneous, and to be done subject wise, university wise. It is in respect to CWJC 2024-2024. Alright, so these two main points are emerging out as a solution before the Education Department and before the University Service Commission. So following these 2 points, they can further continue their selection process or resume their interview process. Alright, so therefore they partly dismiss LPA 622, LPA 890-2023, and the observations are opened for implementations in the commissions or the education departments further steps. Okay, hence A, B are to be the points A, 39 in para 39, the points, the 2 points that are coming out from this 39 para A, B are to be followed strictly and done. Then the BSUSC can resume the interview process, and hence we can expect from the positive Bihar Education Department and positive, of course positive, Bihar State University Service Commission, that they soon resume the interview process, and of course along with this they soon keep in mind the reservation roster and the backlog vacancies, of course. So we can expect that within few days some good gestures or good notifications will be there in the commission's website, and let's see what's happened. Till then, tata, and if you like my video, then please do some comment for my entire reworking on the judgment, and if possible then subscribe my channel. Thank you.